On behalf of our team at HBKS Wealth Advisors, I would like to welcome you to Creative Financial Solutions for a Restructured Family with HBKS Financial Advisor Donna Kline and Liberty Weyandt, partner and chair of the Family Law Practice Group at Lynch Law Group. Our session is scheduled for 60 minutes and has been previously recorded. A copy of the presentation materials is available for download in the handout section of the GoToWebinar control bar. We value your feedback, so please complete the survey at the end of the session to let us know how we did. And if you would like more information from Donna or Liberty, please let us know via the survey or by email. For more information and insights, please visit our website at hbkswealth.com/insights. For more information about Donna, she's a certified divorce financial analyst, a certified divorce coach, and a financial advisor at HBKS Wealth Advisors. Liberty is a partner and chair of the Family Law Practice Group at the Lynch Law Group. Both Donna and Liberty are trained in the collaborative process of dispute resolution. Donna, let's get started with you. Divorce is a complex circumstance, so where would you like to begin?
Well, you're right. Divorce is complex. But as a financial advisor, this is a financial advisory webinar. The bulk of what we're going to discuss today, it will be the financial aspects of divorce. But we would be remiss if we didn't acknowledge the emotional aspect of divorce, right? Going through divorce is a grieving process. You're mourning the loss of your marriage. You're concerned for your children. You're worried about your financial future. These are real feelings. And it's true of both parties in divorce. Both parties have these concerns: betrayal, resentment, fear. These are the emotions that are the core of conflict. Right? Another component is timing. Divorce is rarely a snap decision. Typically, the person who initiates the process has been thinking about it for a long time, may have even moved on emotionally before divorce is even suggested, while another party is completely surprised by the news. So you have one party further down the healing train, while the other one's just starting that mourning process. So understanding where you and your spouse are along this grieving journey is an important step to understanding and ideally minimizing conflict. So divorce is a lot to process, but understanding the emotional aspect will help in your negotiation going forward. So that said, three primary components of today's webinar are: one, which experts do you need in divorce, and how can they help? Two, what are marital assets? What are the different kinds of marital assets? How can they be divided? And three, we're going to talk about the creative solutions that help preserve family wealth and protect financial futures. Because how you come up with a practical resolution in the midst of an emotional circumstance is important.
Donna, that's where your coaching training comes into play.
That's right. I'm a certified divorce financial analyst, right? So I'm trained to analyze assets, expenses, taxes, and I help families arrive at creative solutions. But I added certified divorce coach to my training because I wanted to increase my ability to walk people through the hills and valleys of divorce, to really appreciate the emotions that are affecting their decision making, and help them keep the focus on what's ahead beyond the actual divorce.
Okay, so let's say divorce is imminent. Liberty, what options do clients have from a legal perspective when approaching divorce?
That's a great question. When I meet with clients for the first time, it is really important for them to understand that they do have process options. Many clients come to me thinking that litigation is their only choice, and that couldn't be further from the truth. The first process option, which we talk about, we call the kitchen table settlement, which in essence is a process where spouses are able to have a conversation in the privacy of their own home, or maybe they meet at their local Starbucks or Panera Bread and talk about how they might resolve whatever their disputes might be. So if it's spouses who are trying to divide their assets, or co-parents who have custody issues, or maybe there's some support that they need to figure out, sometimes people are able to sort those issues out themselves without lawyers. Typically then what happens is one or both parties hires an attorney to then prepare the contract, which is what we call a property settlement agreement or a marital settlement agreement. And that puts in writing the actual terms of their agreement. Now, divorce lawyers can't represent both parties because there is a natural conflict there. So that is why sometimes a couple will choose to only hire one attorney, and that attorney will specifically represent one of the spouses to prepare the paperwork and ultimately finalize the divorce. But certainly both spouses have the ability to hire their own lawyers if they each want separate legal representation. The next option is what we call mediation. And mediation is a type of alternative dispute resolution process where you hire a neutral third party. That person's called the mediator. And the mediator's role or job, so to speak, is to help facilitate the conversation back and forth between the spouses or co-parents to try to help them find middle ground and ultimately reach an agreement. So where you might not be able to have that conversation alone in the privacy of your own space at a kitchen table settlement, you may be able to do that with a professional guiding you through some of the more challenging topics. Donna and I are both trained in mediation, and it is something obviously that we're passionate about, in part because it gives our clients the ability to resolve their disputes outside of a court process and allows them to have some control in the outcome. Now, what happens in a mediation, if you do ultimately reach an agreement, you still would hire an attorney, or each party would hire attorneys to prepare that property settlement agreement and the paperwork necessary to actually obtain a divorce decree. What the mediator typically does is they prepare what's called a memorandum of understanding, which summarizes the terms of your agreement, and they provide that to the attorney to prepare the actual contract. It's also important to know there's different types of mediators. There's attorney mediators. There are financial professionals who are mediators, like Donna. And there are also mental health coaches that also do mediation. They are skilled in co-parenting plans. So sometimes you just need to kind of plan a little bit on what type of mediator is best for your particular situation. All right, the next process, which is a step up from mediation, is called the collaborative practice. And in the collaborative practice, both spouses or both co-parents must hire collaboratively trained attorneys. And we sign what's called a participation agreement. It's a contract that sets forth the terms, so to speak, of the negotiation process. And as part of that contract, you are specifically agreeing to not litigate in court, and the spouses or co-parents are hiring their attorneys to work together as a team, as opposed to lawyers fighting one another in court. Another difference of the collaborative process is that we focus more on the parties' individual interests and goals, as opposed to what Pennsylvania law might say or how a judge might make a decision. So it is a unique process in that we are able to identify specific issues within that family and come up with creative and unique solutions to their particular problems. The lawyers also work together to prepare that property settlement agreement and finalize your divorce. In the collaborative process, there's pros and cons to all the process options, but in the collaborative process, it's important for clients to know that when we choose the collaborative process and we sign that participation contract, that if for some reason the case were not to settle in that process, the lawyers cannot then represent clients in a court process. The clients would have to retain new attorneys for litigation purposes. One of the key benefits of the collaborative process that's very different from all the other process options is that we have the ability to bring in trained professionals into our actual team meetings. And we use financial advisors, we use mental health professionals. There are a whole host of professionals in our communities that are specifically trained in the collaborative process to be able to support the unique issues that we deal in the process. So instead of having experts in litigation, for instance, who are hired to argue against one another in court, experts can be retained as a neutral, so they're not taking sides with either party, but they're there to help support the process and provide information so that clients can make good decisions. Typically, whether you're in a mediation or a collaborative process, clients have much more control over the outcome of the process. as opposed to the last process option, which is litigation. We're not going to focus so much on litigation today. We could spend an entire webinar on that issue. But obviously, the litigation path is where you have a judge making decisions for you. And typically, the clients lose much control in that process. It's, I call it the train to the courthouse, right? And you're following the court's timetable and the court schedule and the court requirements. And typically, lawyers act as mouthpieces, so to speak, for their clients and advocate that way. It is adversarial in nature and is often destructive and harmful to families. Now, certainly, some cases need to go through the litigation process if there are particular facts of their case, or you're dealing with physical abuse issues or high conflict custody cases, or you have two people that simply can't agree. The courts serve a helpful purpose in that regard, in that, you know, they make decisions when the parties otherwise can't. But it's important for clients to know that 90–95% of cases settle anyway. So if you have that understanding from the beginning, you do have the ability to try to pick an option which can maximize your ability to be successful in your transition as a divided family, yet at the same time try to maintain relationships that you might want to retain for co-parenting reasons or business relation reasons or just family reasons.
Thank you for explaining those, Liberty. So in all of these various options, which stage is most appropriate for a financial professional to be brought in?
Well, a financial professional can be used in any of the options. I certainly have had clients do their kitchen table settlements where they consult with a financial advisor in making their decisions. As I indicated, in mediation and collaborative, we have the ability to specifically include financial professionals. They are also used in the litigation process as experts, typically that are making different positions for the different clients, right? Some of the things that we use financial advisors for to help us create budgets, they can help us analyze different types of assets. We can have them help us figure out taxing consequences with respect to what might happen when we transfer different assets. They certainly are extremely helpful in having us plan on how do we transfer retirement assets. We look at, is there an asset that might be more beneficial to transfer this way or that way? We have them sometimes help us with qualified domestic relations orders, which are the documents necessary to be able to transfer retirement accounts from one spouse to the other. And there are also financial professionals who can help value businesses.
Thank you. Donna, what are some examples of assets that are part of the divorce process?
Right. So Liberty already discussed a lot of the details you see here, and we're always very happy to help families, minimize the conflicts in the divorce process or help present their case, help the attorneys present cases. Some examples of assets, and the reason we talk about this is that first and foremost, not all assets are created equally. So the role here in dividing marital assets is that the financial is going to do what Liberty said. We're going to assess the tax consequences, the cost of holding assets, liquidity issues, which makes dividing marital assets a careful practice. For example, the marital home. Now, depending on the length of marriage, there may be substantial equity in the home, right? The home may be large. Children may be grown. The tax burden could be very high, right? The home could be very expensive to maintain. So regardless of the emotion perhaps associated with the home, is that property something that should be kept or sold for a practical purpose? Vacation homes, there's different taxation on non-primary residences. They have a cost of upkeep. Are they affordable for one party to maintain, or should it be sold? Then you have income-generating businesses like rental properties and other types of businesses. What type of income are they generating? How are these properties or businesses held? Is it a partnership between the parties? Is it just joint names? Is it a corporation? Does it make sense to sell them? Or should there be a creative way to find a way to keep them? In some cases involving the legacy of a business, estate attorneys need to be brought in to make sure everybody's desires for the future of that business are kept. Then there's investment and savings accounts. And these are your stocks, bonds, mutual funds, your taxable accounts. You know, they have, what's the cost basis of these assets? What's the risk associated with these assets? Are they liquid? Is there a penalty if they're sold prematurely? I mean, some investments have very specific qualification standards. So it might not be advisable for one spouse to take an illiquid, highly risky asset. So which spouse would be the best? To keep the asset, or should it be sold? And then there's qualified accounts. And by them, I mean the 401ks, the 403bs, your ESOPs, your pensions. They require a domestic relations order to be filed with the court before they can be divided. And it takes time, and it has to be done very carefully. Some of these qualified plans offer lifetime income, as with a pension, and some, like a 401k, have accessible cash now. So the role of the financial advisor, or the financial divorce specialist here, is to question which is better. Is it better for the client to have liquid assets now, or is it more beneficial from a financial perspective to have stable income in the future? So the divorce planning process helps people make those decisions.
Thank you for that explanation. Liberty, I'm going to ask you the next question. And since you and Donna are both in Pennsylvania, let's just focus on this state for now. What are some of the rules for asset distribution and support in Pennsylvania?
So with respect to support, there's 3 different types. The first we call spousal support, and that is support that someone can request when spouses are living physically separate in different residences, and it occurs before anyone actually files a divorce complaint. The second type is what we call alimony pendente lite, long name, short name APL, which basically means support during the litigation. So from the time someone files a divorce complaint throughout the entire time of the case until you have a property distribution, which would either happen by a consent agreement or a decision by a judge and a divorce decree, you can collect alimony pendente lite. Third type is alimony. And alimony is support after your divorce is over and after all of the property distribution has been completed. And the court looks at these different types in slightly different ways. Spousal support and APL are guideline driven. So our state statute has figured out a calculation, so to speak, as to how we figure out what is an appropriate amount of support between spouses by basically looking at each spouse's income. The taxes, of course, are removed, so we're dealing with net incomes at that point, and a calculation is then applied to determine what that amount is. For the purposes of the webinar, it's really difficult to be able to show you that calculation, but let's just assume that calculation has happened and that's what the support number is. With spousal support in APL, it's typically you follow the calculation. There are some variables in the statute that allows a guideline to be enhanced upward or decreased downward, but generally the guideline amount is the guideline amount. With alimony, it's very different. Alimony is needs-based. It's not something that you automatically get or is something that is mandatory, but instead the court has 17 factors that it considers with respect to whether someone is an alimony candidate or not. A few of those factors include the length of the marriage, the relative disparity of the income in the parties, the lifestyle that was maintained during the marriage. Do you still have minor children that you're raising? Issues like that are considered. And once those facts are applied, then the court makes a determination as to whether or not alimony would be appropriate in the case. Now, alimony is not guideline driven. In practice, sometimes judges will use the guideline as a starting point. However, that is not mandatory. They can figure out a different amount which they believe is more appropriate based upon the facts of the case. And the duration of the alimony, also, there is no bright line rule for that. So it's very fact driven with respect to what the court believes is equitable insofar as what someone needs in amount and duration. In practice, typically alimony trends downward over time. So for example, if you were awarded alimony for 4 years, it might start at a certain level, let's just say, for example, $1,000, And then year 2, it might decrease to $750, $500, and so on. So in a nutshell, that's how spousal support, APL, and alimony works. When we look at child support, and we always figure out the spousal support component first, and then we figure out what is the child support. Because in essence, what happens is once money transfers from one spouse to the second spouse, then each spouse is have income on their columns, right? And so we figure out the child support, taking into consideration that one spouse now has less and the other spouse has more. Child support is also guideline driven, and so the calculation is applied, and the state has done its research to figure out if an intact family had these income levels, so that this is the amount that the state has determined would most likely be spent on one child, child 2, child 3. Typically, you get the most support for child 1, and the amounts decrease for children 2, 3, and so on, because there's some assumption there that there's sharing of resources. With child support, there are also variables that can increase or decrease the guideline, some of which include who's paying for the medical insurance, what are children's special needs. There may be childcare or daycare expenses or extracurricular activities that can also be included as part of the support amount.
Thank you for that detailed explanation. So, in Pennsylvania, for example, it sounds like there are pretty regimented guidelines. So does that mean that there's no room for negotiation? Donna, would you like to take this one?
Right. So you've just learned about how many factors can actually go into these formulas. But then eventually it will be a formula, and it's not really needs-based as much as it's income-based, I guess would be the main summary. So where I come in with the creativity portion of my work is I feel families are actually able to make smart decisions on their own for their financial future. Right? Their household is changing. Instead of one, there will likely be 2 households to maintain. And what's the best way to get it done? So as a CDFA, I approach the divorce just like a financial planning process. We're not looking at the value of the asset only. We're looking at its growth potential, the cost of holding it. We're looking at relative incomes of the parties. We're looking at the expenses required to run the household. Right? So we're also paying close attention to the priorities of the family because they're different within every family. For example, Pennsylvania has guidelines, as Liberty explained, but there are just many, many real-life instances where those numbers just aren't a good fit for the family. Example could be something like earnings, variable earnings. One party could be paid primarily on commission. So the month-to-month available income could be different. The support number might not accurately reflect the cash flow available on a monthly basis. Sometimes this PA guideline number is just too high for one party to maintain due to other marital expenses, things like student loans, cost of college, cars, and insurance for children. And if one party is ordered to pay a support figure more than he or she can afford, then it's possible the expenditures on the children would have to stop. And so parents can work together to determine what really are the costs for supporting their household, supporting their children, who can pay what. And then they can come up with a support number that actually makes sense for their family. Right? And this is why bringing in a divorce professional can be very helpful. And one more thing is the timing of liquidation of assets, rental properties, businesses built together. Right? Just because a family is divorcing, it's not always advisable to sell these assets immediately. Right? It just might not make good financial sense. It might not be a smart long-term decision. So every family has different needs, and the ability of them to work together and be flexible around the guidelines of the family law goes a long way.
What I'm hearing is that doing your best to work together, or at the very least, work with a divorced financial professional, really can make a difference for the long term. Can you tell us more about that?
Yeah, absolutely. Because part of the planning process is thinking beyond the actual process of divorce. It's thinking about the mutual financial futures going forward. So let's use an example of the sample family, if you will, right? So one spouse of this family is 36 years old, let's say, makes $175,000 per year, and had a bonus last year equal to $84,000. Spouse 2 is a teacher, makes about $45,500 a year, might have a side job. I use Mary Kay, but it could be any type of income generator, an independent business. They have 2 children, 7 and 4. They're young. They've only been married 9 years. Throughout the marriage, the first spouse traveled often with work. So it's pretty much an understanding that the children will spend most of their time with spouse 2. So when we look at the family from a top-down perspective and we just look at their assets, let's look at their assets. Here's what they've accumulated. They're young, but they've done a pretty good job so far. They own a marital home worth $450,000. They have a mortgage against it of $320,000. They own this vacation cottage, fishing cottage, whatever it might be, worth $100,000. The mortgage is low, $18,750. They have about $100,000 in taxable brokerage accounts, about $225,500 in a 401k, and a small pension for $70,000. So looking from the top down, right, that's one way to analyze assets and potential division. But we're going to look just a little further in this process, right? We're going to look into the needs of the family. And so when I work with couples divorcing and individuals, but I ask for a lot of details, right? A lot of financial details, because I don't want to miss things that you don't normally think about on a day-to-day basis, like the cost of pet food or the vet visit, right? Or money you need to set aside for vacations. You know, what kinds of activities are your children enjoying? What do they cost? We want to really have an understanding of what it takes to run that home as it is now, right? And different families have different values. You know, some may value private school as an important expense for the children. Others may prefer to, you know, it's absolutely mandatory that they save for college for the children. It's just a value they really hold. Sometimes there's expenses that are still in the marriage, like parents' existing loans, or parent plus loans if the children are older. One parent has taken on the risk of a parent plus loan. There's health insurance costs, which parent will cover the children. There's that second residence. That's the main thing to consider, is now we have one party living in a separate house. What is the expenses of maintaining that home? What's affordable, actually, sometimes before they split. So we want all these expenses detailed because we really want to know what net income is of the family. What's the cash available every month running separate houses? Is there enough income for those types of expenses? So let's say one idea that the spouses decide is acceptable for both of them is that spouse 2 will stay in the marital home with the children, right? Stay in the school district. Spouse 1 will take the cottage. They agree to share in the taxable accounts, the 401k, and second spouse will keep the pension. Right? Now, this is just one example. When I'm working with couples, we try many, many possibilities, okay? And we come up with the ones that work best for the family. Because remember, each of these assets come with some sort of a cost. If spouse 2 gets all the equity in the marital home, the expenses also come with it. So we have to include that. So if we now assign expenses of each asset, taxability of each asset to the corresponding parties, use the salary and bonus of the party on a monthly basis based on the prior year's income. And then I lump these expenses, which have been very detailed, but for demonstration purposes, I just have them in one line, which includes taxes, cost of the second residence, kids' expenses, all that we discussed. And what I'm looking for is net available income. Well, without any support payment being paid, and spouse 2 attempting to run the larger house, you can clearly see that they're not making ends meet. Spouse 2 is not making ends meet with the income that he or she is bringing in at this time. And when I work with people, these can be very complicated spreadsheets, but one of the best things I like to do is utilize my software to actually chart what we're producing out of these spreadsheets. It's just more visually appealing to people. They can actually see what this looks like on a long-term basis if it continued the way it is continuing now, right? So it becomes easier to understand that a change needs to be made, okay? So we presume in these calculations growth rates, inflation, all of which I explained to the families, right? But if you have extra money each month, as spouse 1 would here, it's also assumed that the spouse is able to save it, invest it, and accumulate wealth over time. So when you look at another example, which is their relative net worth, since spouse 1 is able to save money each month, you can see this dramatic disparity and net worth as time progresses. So my goal as a CDFA, or collaborative neutral, is to narrow that gap as much as possible, right? Make it more equitable, work with the parties, and help them discover how they can best fill in the gaps for themselves. So we go back to the top-down approach, and we use the PA guidelines that Liberty described, right? For using gross income, net of taxes, a few adjustments for healthcare, etc. The PA guideline, based on this family's income, spits out a number of $3,000 a month in child support each month. Okay, so if we just put that $3,000 support in, take it from spouse one, give it to spouse two, and look at it from a top-down approach, it certainly looks like spouse two is able to save some extra money every month, and spouse one can afford $3,000 a month. All right, and then when we take that example and we again chart it with grow assets and grow the accounts for inflation, we get a relative net worth more in line with what we want to see, right? What me as an advisor, I'm hoping to achieve for families that are splitting up, right? We're looking for these lines to narrow together. Okay, so they both have prosperity in their future. But you really think, if you don't think through everything in a divorce case, you may think you have solved the problem with the support award. But in actuality, it's not solved. And there's a reason. And that's the source of this bonus that you've included in the income of the payer. Right? It might look good on paper. But spouse one says, I don't have that much liquidity each month, because my bonus is paid in stock options. Right? It's paid in restricted stock. Performance shares that don't vest for 3 years. Last year's commission payment was a windfall. I don't know that I can keep up those sales in the future. Right? So even if the bonuses are impacting W-2, or showing up as income, and going into the calculation for PA guidelines, the reality is that one spouse simply doesn't have the liquidity to make a $3,000 per month child support. So if we take the bonus out of the equation, since it's not actual cash necessarily when it's awarded, okay, and we reflect the actual take-home pay for spouse one with the PA guideline support, the taxes, the expenses, the cost of maintaining a second home, it's more apparent that spouse one falls short every month. And this right here, this slide, is a very pivotal moment, right? Because from the top-down legal perspective, spouse two certainly has a right to that $3,000 in child support. That's the calculation. But utilizing this sort of, it's not really phantom income, but inaccessible income in the formula makes it nearly impossible for spouse one to make these payments. Right? Remember when we talked earlier about people having fear and resentment and things being the core of conflict? Both spouses in this picture are worried about their financial future. So this is where, conflict can arise. Liberty, if there's a situation like the sample family and the PA guidelines come out and say $3,000 a month, but spouse one can't afford it, what happens?
Well, if you're in a court process, unfortunately, the court doesn't really care. It's not that the court doesn't care, right? It wants to care, but the guideline is the guideline, and the law puts support first. So child support comes before all of your other expenses, followed by your ability to pay your spousal support comes before all the other expenses. You can certainly try to modify. If you're not able to make the payments, the court's going to find you in contempt of the court order, and you can attempt to modify. And sometimes there is a negotiation process, even in litigation, where spouses could agree to accept less than the guideline amount. But if you're in a highly contentious type of case, typically, the guideline is the guideline. Now, there are sometimes judges will hear, we are a court of equity. And so there are some examples where courts might grant a decrease in the guideline if there is a compelling reason to do so. However, that's not, I would not say that happens very often.
So that process that you just talked about, what's the time frame of something making a change? What kind of expenses are involved? How many hours does it take to successfully get a modification?
Some of it depends upon what county you're in Pennsylvania, but if I use Allegheny County for an example now, it can take months to go through a modification process. Sometimes you're not even entitled to modification. Courts will say there's already an interim order in place and we'll readdress it at the time that we handle equitable distribution, which is the time when the court divides all the assets. So you might not be granted a modification hearing immediately. You may have to wait to the end. If there's a compelling reason such as a job loss, then you might be able to get an interim hearing. And the process happens in multi-steps. So you have to file the modification, and that's an act in itself that requires attorney time, or sometimes clients will do that piece themselves. Then you have to appear typically for a conference, which is a time to try to settle it. The court does encourage settlement amongst the parties, even within the court process. And if you can settle, then, the modification could happen then, or you would enter into a consent order allowing that to happen. But when you don't agree, then it would escalate to an actual hearing, typically before a hearing officer who would make a decision with respect to either the guideline amount or the modification request, whatever the issue may be. And even then, that doesn't necessarily mean it's the end, because if one of the parties doesn't agree with the decision that hearing officer made, that can be appealed to the next level. So, I mean, I've had that 6 months, a year, or longer sometimes if it's a complicated circumstance.
That's a long time and a lot of effort. And it's something that could continue in a cyclical sort of process for decades as income levels change, right?
Support's always modifiable, based upon a change in circumstance. And courts typically will bring the parties in every 3 years or so, because courts assume that incomes have changed over course of time, or circumstances have changed over course of time. Your custody schedule can also impact your child support amount. The more custody, if you have a shared custody time, they're going to give some discount in the child support amount, because the court is understanding that money's being spent on your child while you have your child in your custody, but then you're also transferring some of your income to the other spouse when they have custody. So
there's a lot to it, and I really appreciate that. I mean, I'm exhausted listening to it, to be honest with you. But I know in some cases it needs to be done. But if there's a chance that, if we're just talking about a disagreement over affordable or how child support is paid, right? Is that process necessary? Because here's my bigger question, right? What about those children? Their ages 4 and 7. Okay, remember, they're just young kids. If their parents remain in this type of a conflict, once a year spending 6 months to modify support, they're using the court system to attack each other over money. Who's winning, right? Not the children. Parents are now spending their, the child's formative years battling in court, right? So I know we could keep going about that, but I just want to point out that this is kind of where I believe that parents lose their focus. This is when they get caught in the conflict and forget what is really important to them, right? They've made this fight about the differences and not really, the common good, right? Yeah, I know you're saying the court system is designed to protect children. I just think if we're talking about a few $1,000s, is it the child's best interest to keep parents in conflict? That's why I do what I do. And I think that's why you do what you do, Liberty. We don't want that for families, right? There is a way. We're talking about just timing of when bonuses are paid, right? There is a way to make an agreement that works for both parties, even if they can't stand each other, right? If parties can keep the focus, right, on the common goals, they both love their children, usually, right? Whatever those goals are, specifically your family, there is a possibility to meet in the middle, find a creative resolution that both parties can agree upon. And so every case is different, we know. But when as a financial, when I have parents come to me with this type of potential conflict, we start by examining, what really is affordable on a monthly basis. Right? What expenses of the family are mandatory? Where is there some flexibility? If this is a commission or options or performance shares, when are these paid? When do they vest? How are they taxed? What are the costs for the children? When are certain expenses going away? How are you filing taxes? I mean, does it make sense to technically stay married to save tax dollars and just have a physical separation? So it's a trial and error of multiple possibilities. And we work with families, I work with families, you do too, that to come up with one that works for both of them. And I don't have an agenda, right? It's not like we're marching through a certain timeline, like you were mentioning, Liberty, the timeline of the court, right? They're not working on any other timeline than their own. And there is no goal in the room of whether or not you get divorced. It's certainly not my show. It's about the family, and it's about facilitating them through the emotional part to make practical, smart decisions, right? Help families figure out what works for them.
Donna, can you share with us some examples of potential resolutions that might be formed within a family?
Sure. You know, we've worked on many cases, Liberty and I, and but here's an example. Let's say a family, they've been married about 20 years. They're both high income earners, but dad maybe makes 5 times more than mom when you account for the bonus. But these are bonuses that stagger. Some pay immediately. Some don't vest for 3 years. Some are stock awards. They have 3 teenage children. There's really no qualification for alimony here, but child support is definitely an issue. So again, we'd start with something like the base salary. And with the PA guidelines as a guide, right? What is an acceptable base child support that could be consistent each month, and then work out a way the bonuses can be paid. So maybe they decide that until the first child graduates, the husband will pay $2,500 a month. Then they already calculated the step downs for themselves, $2,250 per month after the second kid, and $1,625 after the third kid graduates, right? Then there's no more base support. But these bonuses are being earned during the time of child support. So they can work out a way to pay out bonuses even after the children have aged out if they were earned during the time they were there, as if the bonuses were included in the calculation. There's a lot of testing behind the scenes that we do, and the software that can align multiple scenarios next to each other. But I'm working with these people. They're intelligent people. They can solve their problem. They're involved in this process. So another example, a little bit different, is maybe a long-term marriage where mom stayed home to raise the children. And it could be dad that stayed home. I'm trying not to stereotype, but somebody stayed home to support the other's career. Right? Somebody worked while the other person studied, went to college. Somebody raised the kids, so the other party could choose a career path, right? Move their way up the corporate ladder. They didn't have a lot of money when the kids were young, but now somebody's making a very healthy living doing all that effort, right? $500,000 a year, even growing. But now there's a divorce. There aren't a ton of assets available since savings wasn't that possible while we were growing and raising kids. But what's the right thing to do here? We talked about those emotions of betrayal and resentment, right? What's important to each party? How does each party feel? What's the right thing to do? So one way to handle it is you have an alimony formula. You can calculate, using some guidelines, but get an idea of what makes sense on a needs and ability to pay basis to award alimony that grows over time. As the payer continues to grow, the payee can participate in success for a while. We can agree to fund some education for one party. So the stay-at-home party could actually re-enter the working world, earn a good living, an education, be self-sufficient, feel confident in their financial future. You can agree to support children in college. You can agree to support sharing bonuses over the next 3 years. It's just, I'm just saying there's ways to address this fear, resentment, and a divorce. And there are ways, it's worth a shot, to find a way to structure a settlement that appeases both parties.
Thank you for those examples. I want to switch gears a little bit here. We mentioned insurance before, and I know that's an important component of this process. So can you explain the role that insurance plays in these settlements?
Yeah, absolutely. So in any financial plan, where you're evaluating the what ifs of what could go wrong. And for example, insurance is a cornerstone of that plan. Right? You want to protect your assets. You want to protect your income stream if one party were to pass, or have disability. Right? So you're always looking at a way to protect what you have as an agreement. That's no different than a divorce, right? So there might be an agreement in place that the couple, like those last two examples, they worked very hard to find something they could both be comfortable with. But what happens if the payer dies? Where is alimony or child support coming from if it's not insured? So if you're relying on those payments, it certainly makes sense to protect them. So, if you have a legal agreement to pay as a provider, even if you're divorced, the recipient does have an insurable interest in you. And that should be protected. It's for everybody's welfare. So I work with couples on this, and we talk through the what ifs, what could go wrong if they're in separate households. And not just life insurance, but other types of insurance for children driving cars and things. What type of plans can they put in place to protect the family and the plan they worked so hard to design?
Excellent explanation. Thank you. So as we come to the close of this hour, Donna, Liberty, any final thoughts on the value of working together with professionals to ensure an acceptable outcome in divorce?
I guess the most important thing, I think, is a team, right? Divorce is emotional. If you invest in the right professionals, it can have a very positive impact on the decisions you make. You want to look for objectivity, people that believe in what your common goals are. It's your goals. And you're not expected to know everything into a divorce. So sometimes you do have to rely on people. But you can also still lean on people that help you make decisions that are best for your family.
For me, when I work with clients, I really try to help them focus on future planning as opposed to rehashing the things that happened in the past, right? And court typically is we rehash things that happened in the past as a way to convince the fact finder to rule in one way or another. But when you're working with professionals in an out-of-court process, the past doesn't always have that much of an impact on us, right? Because we're working with clients to think forward and future plan. How do we best use the resources that you currently have to help you transition into the next phase of your life? How do we use the resources to plan for your children's needs? How do we use your resources to help plan for your retirement? And so when you have a team of professionals that all have their individual roles, right? The lawyers are really good at the lawyering piece, the drafting the contract, getting the divorce decree. You work with your financial advisor who's really strong at helping us really maximize how do we use those retirement benefits in the way that best meets the needs of the family. How do we work with cash flow problems? How do we sometimes we even generate options on how can we generate more income. When you have a full team, you're able to actually plan an outcome that puts you in the position that's most favorable to you, as opposed to a court process where you generally lose control and a fact finder makes a decision and that's the decision. And unfortunately, you generally have to live with that decision. When you have a choice between one or the other, certainly I advocate for clients to choose the process that gives them control in the outcome and allows them to properly plan for their future.
I agree, Liberty, and even if they think it's not possible, it's worth a try. It's really worth a try. I think in the long run, their children will thank them, and they'll thank their former selves for doing the right thing during a tough time.
I wholeheartedly agree.
Mm-hmm.
Donna, Liberty, thank you so much for taking the time to walk us through some of these options that I'm sure many of us weren't even aware of, and to explain and provide some examples of the value of working with professionals and just how positive of an outcome you can have despite a situation like this. For everyone who has watched today, thank you. We hope that you found this information helpful. Donna and Liberty's contact information is here, and also when you fill out the survey, you can request to speak with either or both of them as well. So thank you again, everyone, for your time, and have a wonderful day.
Thank you.